Hello everyone, hope you have a nice day and welcome back to my channel. Today we discuss about legal environment in business atmosphere. So the legal environment is a business refers to the rules and regulations formed by different legislations or government bodies to govern the day-to-day activities of the business organizations. The legal environment includes the legal system and the social, economic, and the political factors that influence the legal environment. The legal environment in the business sector has much important in shaping the behavior of the business in a particular industry and the legal environment rules and regulations provide various frameworks for other disputes, protecting the rights and freedoms of other individuals and a group of people, and also maintaining a regulating the behavior of the business in the society. The legal environment can be of various types like the Indian Contract Act, Sales of Goods Act, Partnership Act, Criminal Law, Tax Law, Property Law, International Law, Labor Law, Environmental Law, Intellectual Property Law, etc. The companies must comply with the rules and the regulation of the legal environment to avoid different legal liabilities and to maintain their reputation in the market also. The legal environment is one of the most important topics for the UGC NET exam. So it covers a significant part of the commerce syllabus also. So in these articles, we will study what is legal environment and its different aspects, types of the legal environment and its nature and important we can expect. So the team legal environment, first of all, the team legal environment includes various legislations that have been passed by the government authorities, court judgments, or any of the government administrative orders, or any of the decision that have been taken by various commission or agencies which is applicable at the center state and also at the local levels. To exist, a company needs to follow all the rules and regulations set up by the legal environment. The structure of the legal environment is very complex and dynamic, which plays a crucial role in shaping and structuring our society and economic as a whole. So the now types of the legal environment. Few important types of legal environment which affects the company are now discussing I am right now. First of all, social environment. Under the social environment, rules and regulations govern various social issues and concerns like environmental protection, discriminations, and issues like human rights. Now, competitive environment. Under a competitive environment, there are specific rules and regulations which are followed by a companies to avoid authentic acts. These includes intellectual property rights, protecting trade secret laws, and antitrust laws. These are the laws that uh, uh, provides a framework for companies to maintain a healthy competitive level. Now, international legal environment. The international legal rules and regulations are made to govern the business activities between two different countries. International laws are like trade laws, contractual agreement between different countries, and regulations of certain kinds of the industries through these international legal laws. It is possible to have good communication and smooth trading of goods in services between the different countries. Now, regulatory environment. Regulatory environment rules and regulations are generally made by government agencies and authorities for the concern of public safety and fair competitions. So, Federal Communications that is FCC, and the Security and Exchange Commissions, that is SEC, are examples of the regulatory bodies. Now, domestic legal laws. A company in a specific country operates under certain rules and regulations of that country, which is regarded as domestic legal environment. Now, in a domestic legal environment, there are three phases: local, state, and central. Sometimes it includes the federal systems where the state and the center can make decisions together. Now, examples of domestic legal environment laws are trade laws of a country, taxation laws of a specific country, labor laws, and other commercial and environmental laws. Now, different aspects of legal environment. So, there are various types of legal environments with their own set of rules, regulation, and laws that the business has to follow to exist in society. A few of the significant legal environment has discussed right now. First of all, Indian Contract Act 1872. The Indian Contract Act, which has been in effected since 1872, has some guiding business organizations in entering, maintaining, and discharging various obligations under this act. So there are certain features of the Indian Contract Act which have been discussed right now. At least two parties. There must be at least two parties to the contract. One cannot make a contract with oneself. At least two parties are required to form a valid contract. Other offer and acceptance. There must be an offer and acceptance. There must be at least one party who is making the offer and other party who is accepting the offer. Now, lawful consideration. There must be a lawful consideration to the contract. Without lawful consideration, the contract is invalid. Free consent to the contract must be formed with the free consent of both parties. Free consent includes fraud, misrepresentations, or undue influence. Unlawful contract. The intention of both parties to enter into contract must be lawful or which is enforceable to law whenever it is needed. Now, Sales of Goods Act 1930. The rules and regulations relating to this selling of goods in India come under this act. This law gives a framework for the sale of goods in India. Some of the features of the Sale of Goods Act 1930 are explained right now. At least two parties. There must be at least two parties for conducting a contract of sales of goods. One party is the buyer and another is the seller. There must be a contract between the buyer and the seller to sell goods, because a person cannot buy his goods by himself. So there must be a purchaser and a seller. Now, consideration. There must be monetary consideration in return for the sale. Without monetary consideration, the exchange conducted is not a sale. Now, agreement to sell. The agreement between the buyer and the seller to sell a good on a future date also comes under and is governed by the Sale of the Goods Act, that is 1930. Now, movable property. The Sale of Goods Act includes every kind of movable properties other than actionable claims and money. Under this act, stocks and shares and growing crops are also governed. Transfer of property. Under the contract of the sales of goods, the good must move from the seller to the buyer or transfer ownership rights from the buyer to the property seller under the agreement. Now, the Indian Partnership Act 1932, a partnership is a relationship between individuals who have agreed to share the profit and losses of the business equally or in an agreement manner in which the company is carried on by all or any of them acting for all. At least two persons, there must be at least two people to form a partnerships, oral or written. An agreement for partnerships between two parties can be written or oral. It can also be in the form of expressed or implied. Now, profit sharing, the partner must share the profit equally in case of the non existence of any agreement. In the case of agreement, the profit should be shared among the partners in the agreed ratio. Now, liability. In the case of the partnership, the liability of the partnership partners is unlimited. Sometimes the partners' private property is also at stake. Now, voluntary registrations. So, it is not mandatory for a partnership's firm to get itself registered. The registrations for partnership firms is entirely voluntary and depends on the objectives of the partners whether to get registers. Now, partners, the persons entered into the contract are individually called partners but collectively called firms. Now, Negotiable Instrument Act 1881. Under the Negotiable Instrument Act, checks and promissory notes and bills of exchange are governed. Some of the features of the negotiable instruments now I'm discussing right now. Freely transferable. The negotiation instruments are freely transferable from one person to another. A negotiable instrument is payable to the bearer. Now, written documents. Negotiable instruments are written documents that is transferable from one party to another. Act as money. The negotiable instruments act in the same manner and precisely like money, it can also be transferred from one person to another. Consent of other parties. The transfer of the negotiable instrument does not need any consent or does not need to give any kind of notice to any other person at the time of the transferring the instrument. Now, Companies Act 2013. The Companies Act 2013 has been brought into existence by replacing the Companies Act 1956. Some of the features of the Companies Act 2013 now I am explaining right now. Limited liability. First of all, under the Companies Act, the liability of the shareholders is limited up to the amount they have invested in the company. Now, number two, separation of ownerships and management. Under the Companies Act 2013, the companies are managed by professional managers and owners themselves. So, there are also directors in the company who are the company's decisions maker. They take responsibility and make decisions for the company's future growth. Now, independence legal entity. The Companies Act 2013 defines the company as a separate or independent legal entity from its owner. So, define the company as an autonomous body and self governing. The company has the legal right to open a bank account in its name and can enter into deals and contracts with any other person or shareholders in its name. The company has the legal right to sue or be sued. Now, perpetual existence at the company is an artificial body. It has a legal presence that can only be ended by law. The owners, managers, or directors may change, but the company continues. Factors like death, insolvency, and retirement do not impact the company's existence while forming a company under perpetual existence. It has been assumed that the company will continue forever. Now, transferability of shares is possible in the case of the public company, but in the case of the private company, the transferability of shares is not possible. Now, common seal as a company is an artificial body, it cannot make its own decisions. The decisions of the company are taken by the directors of the company, who are the company's representatives. The directors are required to make decisions on behalf of the company which is beneficial for its future growth and existence. So that's the end of the video, my friends. If you like my video, please subscribe my channel. Thanks a lot for watching.